as evidenced by the reflections and the commemoration at the fire department on Sunday. It takes a village to keep and bring people through these things together, and I know the family is very appreciative, as is the family of Al Hoffler, Karen and her daughter, granddaughter, and family. So just a moment of silence, please, for the two of them. Thank you. Clerk Perillo, we have some announcements this evening.
Yes, Mayor, thank you. Jim Burke has been appointed our village assessor effective the 28th of December, and he will fill the balance of the unexpired portion of the term of Assessor Paul D'Amato, which term expires on July 7th, 2025. Congratulations to Mayor Shepro, who was appointed to the Executive Board of the Suffolk County Village Officials Association. Our village offices will close at 12:15 on Christmas Eve, the 24th of December, and New Year's Eve, the 31st of December. Thereafter, the next upcoming Village Board of Trustees meeting will be the January work session meeting, which will begin at 5 o'clock p.m. on January 8th. And last but certainly not least, our annual Ice Festival is scheduled for the 18th and 19th of January, with rain dates of January 25th and January 26th.
Thank you. Now it is time for our public safety and welfare update presented by Suffolk County Police. Thank you for being here.
Hey everyone, I'm Dan Lynch. I'm one of the supervisors that covers the village. I don't have any paperwork to go over with you guys today. I got short notice about this, but if anyone has any questions, comments, or concerns, I'll do my best to answer them or respond to them for the police department. Anything? Nope.
Well, just thank you so much to the Suffolk County Police for having a great presence during our Dickens Festival weekend.
Yes.
We saw you everywhere, and also our Santa Parade. It was appreciated, and tonight there's some function that a lot of the COPE officers are attending with children or something like that.
Yes, there's Santa with a cop in the Target in South Target.
Okay.
That's where they all are right now.
All right, good. Well, we appreciate you
Thank
being
you, guys.
here. All right, thank you. Okay, Clerk Perillo, do you want to take over the next?
Yes, thank you, Mayor. We have two public hearings this evening. The first is a public hearing regarding an application.
Clerk Perillo, can you move your microphone closer to yourself, please?
Yes, thank you.
Thank you.
The first public hearing this evening is an application to the Empire State Development for financial assistance under the Restore New York Communities Initiative for a proposed project at 1506 and 1510-1512 Main Street. May I have a motion to open that public hearing, please?
So moved.
Thank you.
Do we have a second?
Yeah. Second.
All in favor?
Aye.
Okay.
So at this time, we have a representative of the Gito Group with us.
Rob Gito, welcome.
Thank you very much. Good evening. I'm Rob Gito from the Gito Group. I'd like to thank the board and the village for allowing us to have this opportunity to tell you about a proposed project we're working on uptown Port Jefferson. Lisa, if you don't mind.
I think we should move.
Yeah.
Okay. We'll have some further slides to give you a better idea of the location. It is outlined on here, a little difficult to see. Maybe, Lisa, if you can go to some of the next slides, and we'll circle back to it. So you can see this is there are a couple parcels involved. This is the former, most recently, a thrift store. And you have the parking lot and the former laundromat and where Lenny's Shoe Repair once was. And there's also an easement that you can see just to the right of the former laundromat that goes to a project we opened up about 7 years ago, the Hills of Port Jefferson. If you don't mind continuing. Okay, so this gives you a better idea of the lots that are involved. you could keep going, and I'll get into a little further detail of the project. So the project's going to be the proposed project would be made up of 35,290 square feet, a mix of 42 rental apartments, studio and one-bedroom apartments. These are being built for our workforce, grad students, med students, support staff of the hospitals, a more affordable option for people that would want to live in our village. It would also have 1,800 square feet of retail space, and like all of our other properties, it'd be amenity-rich with lounges, a game room, a rooftop terrace, and we can keep going. Thank you. You could just keep going through these slides. The proposed project would be one of the first projects uptown to take advantage of the fourth floor, which would have a give back to the village, which was something that has to be negotiated with the village and developer. And if you don't mind, keep going. These are just some of our other projects that we finished. You have the Hills on the top two slides. The bottom two are the Barnum House where CVS is in Lower Port Jefferson. And there's one more slide which shows our Brookport project, which is where Cappy's Carpet was, and our most recent project, which we opened a couple weeks ago, One North. The reason I'm showing these, we're still in the early stages of designing and developing this potential site. So just wanted to give you some idea of some of the architectural finishes that we've completed recently. This project would be a mix of those, and we'd be working with the village and the planning staff on what the village wants us to look like. We're working with the village once again in New York State for this grant opportunity, which we're very thankful of, and that's why I'm here, unless you have any questions. Thank you. You want me to stay for any questions? Okay, sure.
So just to reiterate, and I'll look to our village attorney, Dave Moran, this public hearing is required by the state to be eligible for the Restore New York grant, which would be used for demolition purposes. Is that what I understand?
Yeah, mostly for demolition, grading purposes,
Site readiness?
to get the site ready for potential development. Yes.
Okay.
You are correct, Mayor.
All right. Thank you. Does the board have any questions for Mr. Gito?
And we'll be following up also with a formal application with the planning board when the new year comes.
Okay, good.
Mayor, if I may, on a point of order, for consistency, the way the public hearing should work after this presentation, any questions of the board to the applicant, and then make open to public comment. Once we close public comment, we invite the applicant back up to address any concerns in public comment, and then any further statements of the board before we close in totality.
Okay, so Mr. Gito, you can take your seat. Is there any public comment about this?
Mayor, you'll need a motion to open the public comment.
Is there a motion to open the public comment?
Motion. Second.
All in favor?
Aye.
Okay, motion carries. Public comment, anyone? Questions, concerns? Okay. Hearing none, do I have a motion to close the public hearing? Public comment? Okay.
Public comment.
Motion to close public comment.
Motion.
Second.
All in favor?
Aye.
Now, motion to close the public hearing. Do we
Close the public hearing.
have a second?
Second.
Trustee Ugrinsky seconded. All in favor?
Aye.
Okay. Public hearing is closed. Thank you, Mr. Gito. Okay. Clerk Prillo?
Thank you. Our second hearing this evening is a proposed local law repealing Chapter 19, Constables of the Code of the Village of Port Jefferson, and amending Chapters 5 and 95 of the Code of the Village of Port Jefferson. May I have a motion to open the public hearing, please?
Then we'll invite Labor Council up for the presentation. After the presentation, open up for public comment. After public comment, Labor Council can come up and address any concerns raised, if any, at the public comment, and any final questions or any final comments of the board before closing the public hearing.
Okay, can you state that one more time?
Sure. As in the last public hearing, once it's opened, an introduction by the mayor or the board, whoever wants to make that introduction, opening the public hearing, have Labor Council present the presentation in furtherance of repealing Chapter 19 of the Village Code. Once Labor Council has completed her presentation, the board can address any questions or concerns to Labor Council, if any. Once that is complete, then we'll have a motion to open the public comment portion of the public hearing. Upon conclusion of the public comment portion, a motion to close the public portion of the meeting. At that point, Labor Council can come back up and address any points or anything that needs to be said, or address any concerns raised at the public comment, and then final either questions or final comments of the board before closing the public hearing.
Thank you. So I guess that leaves it to me to open the discussion. But first, we need to have a motion to open the public hearing.
You did it already. That was done already, May.
Okay. So tonight, we will, as a board, with members of the public, learn about the circumstances that led to the establishment of the 19th chapter of the Port Jefferson Village Code called Constables, and take public comment for such. While an unfortunate, inadvertent circumstance led us here today, that circumstance helped this administration take time to look into the incongruities and irregularities between what the duties and responsibilities of code enforcement is, thanks to the conflicting codes in the code book and the conflicting information found in Chapter 19 Constables, and the collective bargaining agreement and the rules and procedures manual attached to the collective bargaining agreement. This, I brought a little show and tell. This is a code book from 1971 that was owned by Robert Moore, who was a trustee in the first administration when the village was incorporated. He later became the village attorney. And in this code book, Chapter 11 is reserved. There is no code in it for Chapter 11. Chapter 4 is actually the Code Enforcement Bureau code. And Chapter 19 is actually salary and compensation of elected officers. So this is the code book that we currently work out of. And Chapter 11 is code enforcement, and Chapter 19 is constables. So there's been a lot of changes in between, obviously, 1970 and today. So I think tonight what we'll do is our Labor Council will walk us through some of those changes, and we'll have a history lesson of that. Today, the two codes, respectively code enforcement and constable, we hope to understand why they both remain and determine if they should both remain. So we have Allison Matthews of Bond, Shunk, and King, our labor attorney, and her team. They put together a chronological and informational presentation of that process. We also have Alan Schneider here, he's a consultant that we've been working with over the past year and a half, who has nearly 4 decades working in the Suffolk County Civil Service operation since retired. He's been, like I said, consulting with us on this and other numerous issues. But he's been involved in this type of issue for many years, working for civil service and other clients. So with all that said, Allison, would you want to come up?
All right, so we're going to get started. Thank you for your patience. Were you up here? Okay. All right, we're using very old technology, as you can see tonight, so thank you for waiting for that. So we were asked as part of tonight's public hearing to take a look at the history of code enforcement and constable positions in the village, and it actually dates all the way back to the beginning of Suffolk County. So Suffolk County is actually one of 4 counties in the entire state that was formed differently from the rest of the counties in New York. So Suffolk, Nassau, Westchester, and Monroe counties were done by special legislation whereby the powers that were given to other smaller municipalities like villages and cities were transferred out to counties when those counties were formed. So there was legislation by the state in 1958 that created Suffolk County. Because of the transfer of power piece of this, the voters also had to vote to form Suffolk County and to make the charter come into being. So there was a voter referendum also that year when the legislation was passed, and the charter went into effect 2 years later in 1960. So as part of that transfer of power, the charter includes a provision on establishing what's known as the Suffolk County Police District. And as part of this provision, there was a referendum that each town, and to the extent it was an incorporated village, had to vote on, and they could decide whether or not they wanted to join the police district. And at that time, the towns throughout Suffolk County, we all know that the East End towns have their own police forces, but the Western towns at that time did too. So if they wanted to vote to join the police district, those officers who were employed as part of their local police departments would be transferred over to the county. So this is the provisions of the charter. They're still in existence now, and it's the questions that were put to the voters in those towns and incorporated villages deciding whether they wanted to be part of the police district. So the police district would only go into effect if 3 or more contiguous towns, so those that are next to each other, elected to transfer their police functions over to the county and become part of the county police district. And once 3 or more towns made that vote, the police district went into effect, and it was done. That's it. It's irrevocable. The vote can never be taken back. So there also, aside from incorporated villages, that some of them had their own police forces, some of those areas were unincorporated. So if you were in an unincorporated area, whatever your town and the voters elected to do, you went along with that. So the police district, you can see there's a map here of Suffolk County. So we have the 5 western towns, Huntington, Babylon, Smithtown, Islip, and Brookhaven, all voted to go into the police district, and the 5 eastern towns voted to stay out of the police district. And a lot of them still maintain their own police forces. So when this happened, this was going on in around 1960, there was a small portion of the town of Brookhaven, right where you're standing, that was unincorporated, and that later became the village of Port Jefferson. So when the Brookhaven voted to join the police district and transfer their police functions over to the county, that also impacted this unincorporated area. So inclusive of what would later become Port Jefferson went into the police district along with the rest of the town. So the first thing we see, and this kind of goes into the history with the constable position here, is when the village of Port Jefferson became an incorporated village, they had a separate vote later that year, and the village residents said, well, we want a village police department. And Suffolk County came in and said, not so fast, you're part of the police district. So there's litigation that goes all the way up to the highest court in New York. There's a companion case that the U.S. Supreme Court actually declined to hear, all about whether Port Jefferson has to be part of the police district. And the theory behind it was that part of the Suffolk County charter had been invalidated, and it had nothing to do with the police district part. It had to do with how at that time it was a board of supervisors, how they were elected. So the theory was if that piece of the charter is invalidated, the rest of it should be invalidated, and therefore Port Jefferson can have its own police powers, and they have the right to also vote whether they want to be part of the police district. And consistently throughout the court decisions, the courts said no. That vote, even though you weren't incorporated at the time, you don't get a second bite at the apple just because you're incorporated now. You elected to become part of the police district when you were part of the town of Brookhaven. You voted then, you get one vote. It's irrevocable, the functions are transferred, and that's it. So then a couple years later, we start to see from board meeting minutes that there's talk about possibly having constables here in the town. I'm sorry, the village. So in 1970, and we see the very old book here, that's some of this as well, we have Chapter 4 that comes into being, but it's code enforcement, it's not constables. Towards the end of the 70s, the board adopts Chapter 19, which relates to constables. And we know from the board meeting minutes that there was another round of litigation with the county again, having to do with this constable position. But this time it wasn't only Port Jefferson, it was also the village of Patchogue, because they too had constables. And then we know in the next year, the board decides they adopt Chapter 11, and they shift code enforcement over at that point. So why does any of this matter, and what's going on now? So I'm going to turn it over to former Personnel Director of Suffolk County, Alan Schneider, who ran the Suffolk County Civil Service Department for 30, maybe I shouldn't say that, for a very long time. So every position, aside from exempt positions within a municipality, come from civil service, and they must be approved by civil service as part of that system. It's embodied in the state constitution, and there are rules about the job descriptions, how they're created, and the rules that municipalities have to follow when they're part of that civil service system. So I'm going to turn it over to Mr. Schneider to take over the next part of the presentation.
Thank you, Allison. So the civil service system, which was established in 1919 by the New York State Legislature and added to the New York State Constitution. Article 5, and is administered by each county, state, each county, city, and 3 towns within New York State. The Suffolk County Civil Service Department has jurisdiction over all municipalities within the county. In Suffolk County, that is 276 jurisdictions, including the 22 departments in Suffolk County, all of the school districts, all of the 10 towns, all of the villages, all of the libraries, and all of the fire departments. And civil service is the oversight of all employment in each of these jurisdictions. A municipality, as the chart shows you, cannot appoint an individual to a civil service position without the approval of the Civil Service Department use of that title. Once the Civil Service Department approves the title, someone in that department then writes a job spec, which delineates the duties and responsibilities of the individuals who are subsequently hired by the municipality to do the work. And those job duties and minimum qualifications for the civil service positions are requirements that the jurisdiction must follow. And there are restrictions for limiting out-of-title work. When it comes to a constable position, only those municipalities in Suffolk County that are outside of the police district may establish a constable position. And I believe at this time there are only 3 jurisdictions in Suffolk County that have constable positions. And I also believe each of those three jurisdictions have approval for one constable position. That required authorization and approval from first the Suffolk County Civil Service Department, subsequently from the New York State Civil Service Department and the New York State Civil Service Commission, and following that, legislation from approval legislation from the New York State Legislature. Municipalities within the police district, such as Port Jefferson, are without the legal authority to establish a constable position. At this point, I'm going to turn it back to Allison. I'll be able to answer any questions that anyone has.
Okay, so what's on this screen? Suffolk County is has one of the best databases when it comes to their job specifications and be able to find them. You can plug in any title and it will pop up and show you what those job titles are that have that word in it, and you can open all the job titles. It will say everything you need to know about what the job can do, what the minimum qualifications are, whether there's an examination required in order for you to be appointed. It's for all the civil service departments that I have to go to, they have one of the best databases. So when you put constable into that search engine, you get 3 municipalities: East Hampton, West Hampton Dunes, and Fisher's Island. And as Mr. Schneider was saying, those municipalities have 1 each, and only those in the 2, in East Hampton and West Hampton Dunes, have peace officer status. The Fisher's Island one does not. Did you want to talk about this? Okay. So we're going to come back to when that peace officer status, why it matters. That's something that is statutorily conferred on a position. It gives duties and responsibilities that come along with it, and code enforcement officer is not one of the titles listed in the law that delineates who is a peace officer, and it's not one of the positions that's listed in the law as someone who is a police officer. So I'm just going to turn it back to Mr. Schneider for a moment to go over, this is the job description that you find on the Suffolk County database and what it is that a code enforcement officer does.
So there are, in the database of the Suffolk County Civil Service Department currently, are 1,400 and approximately 50 titles. Those titles are used in the 275 jurisdictions in Suffolk County and the 22 Suffolk County departments that operate to run Suffolk County government. So for all of these titles, there is a job description exactly like this, same exact format, with the distinguishing features of the class, which is a general statement as to what the job is supposed to be, typical work activities which delineate the actual work duties, the primary work responsibilities of the job, and the knowledge, skills, and abilities of the individuals that should be contained within the individuals that are hired for the job, and the minimum qualifications for this position. And you can see the typical work activities for a code enforcement officer, which is the title. that the village has been using for a long time. It's to patrol the jurisdiction either by foot or car and note violations of local code and ordinances such as litter, open containers, noise, peddling, dumping, parking violations, etc. Investigate complaints referred by the public or other agencies regarding the violation of codes and ordinances, investigating reports of violations of those codes and ordinances, and issuing summonses to violators of the codes and ordinances, testifying in village court in cases which are contested, and notifying the Suffolk County Police Department immediately when activities of a criminal nature are observed. The skills and abilities are noted. The qualifications are graduation from high school, and the necessary special requirement is to have a license to operate a motor vehicle. And you notice in the distinguishing features of the class, an employee in this title is involved in the enforcement of local town or village code and ordinances, exclusive of the enforcement of vehicle and traffic law, and all other Suffolk County and New York State laws. So that is the job description under which the code enforcement officers of the village are supposed to be working under. Doesn't mean that's what they have been doing. This is what they are supposed to be doing, and this is what the Suffolk County Civil Service Department certified to the village that this is the job description of a code enforcement officer. This is the job specification and the duties that code enforcement officers should be doing. Yeah.
So at the very top of this job, go back 1 second. The very top of this job description, you can see that the code enforcement officer position is specifically delineated as something that is not a law enforcement position. So when we look at the difference between a constable position and a code enforcement officer position, so a constable has the peace officer status. Peace officer is defined in the criminal procedure law. They have statutory authority to make arrests, use physical force and deadly force, carry out searches and seizures, make custodial stops, and issue tickets. Code enforcement officers do not have that authority. They are not peace officers, they are not police officers, they're not law enforcement. It's a civilian position, and it does not have any sort of peace officer, police officer status. In the job description for civil service, it directs those employees to contact the police department in the event that there's any sort of violation of a local, county, or state law, or when there's any crime that's observed. So when we look at the village code provision on constables, there is a provision here on firearms. It's the only place in the code where there's a reference to firearms, but it's tied to the constable position. And if we look at the next slide, there is no constable position here. So periodically, Suffolk County will send municipalities what's called their position control list, and it lists every position that that municipality can offer. So Mr. Schneider was saying earlier that you can only offer a position if the county has authorized you to offer it. And this is how you know if you have that title. You look at your list, it will show you if you have any vacancies, it will show you who's in a current title, it will show you what you might want to fill later on. It's listed in alphabetical order. It's probably hard to see here. We go back impacted the names, sorry about that, the people who are in these positions, but you can see it jumps from code enforcement officer to community service aide, and then jumps all the way past where in alphabetical order you would normally find the word constable. So there is no constable position here, regardless of what label may have been put on a car, what label may have been put on a badge, what label may have been put on an office door. The other issue to look at too is the code enforcement rules, which have been referenced as well. So those rules allow the village to designate code enforcement or members of the Bureau to carry firearms. That's at the discretion of the village board. The only authority other than this where that came from was the village code, but under the guise of a constable position that doesn't exist. The rules also reinforce what you see in the job description from civil service, which is that you can assist the police, but you have to ask if they need your help. They have to give you permission to involve yourself in whatever it is that they are working on. So earlier in the presentation, I had mentioned that there had also been some litigation with Patchogue that got involved in this. It's not just a Patchogue and Port Jefferson issue. In the early 2000s, there was a class action lawsuit, one filed against Patchogue and one filed against the village of Oldfield, seeking $8 million from each village under the theory that their constables were actually carrying out police powers that they did not have and seeking to invalidate all of the summonses and tickets that had been issued. County of Nassau had a similar case to village of Port Jefferson against the village of Woodsboro. That case also went up to the Court of Appeals. At the beginning of the presentation, I had mentioned that Suffolk and Nassau were formed in the same way with their charters, so we have similar issues. There's a police district in Nassau County, and it's subject to the same rules here. So just like in Port Jefferson, in the 80s, the New York Court of Appeals said that the village of Woodsboro had no right to have its own police force or constables. And they enjoined the village and said, you cannot have this position. And not only that, you can't use your village funds to pay their salaries because this position is not authorized. We also see from some of the news articles that are going from the 90s that the Division of Criminal Justice Services denied the application of 3 Suffolk villages, including Port Jefferson, for their code enforcement officers to be registered as peace officers. And that article also references that the Poquat constables were going to be removed from that registry. So that would be the registry that gives that peace officer status, the ability to use a firearm in your employment. That's where that all comes from. The division is going to have to allow you to do that, and that would also give the authority to arm employees. We see in 1995, there was a Poquat constable that fired several shots outside a Port Jefferson bar, did not have a pistol license, and there was no legal authority to carry a firearm. Caused an issue. In Suffolk County, in 1996, the county attorney issued a formal opinion that Poquat constables are not peace officers. So this issue has been percolating for quite a while. It's not new. It just happens to pop up again because at this point in time, the village board has elected to make a change. So if we are going to continue to assign employees job duties that are not only outside their job description, but are outside their legal authority, we're potentially subjecting the village and all of you who are residents here to liability. There could be a lawsuit, just like there was in Oldfield and Patchogue, seeking damages, seeking to invalidate actions. Heaven forbid someone actually fired their weapon. They are not a peace officer. They are not a police officer. There's no authority to be able to fire that weapon in order to perform their job functions. So you can imagine the liability that might stem if that actually happens. Luckily, we've heard that it has not happened yet, but I think at this point the board is not willing to wait for the what if. They're going to take the action now. So at this point, the village is taking steps to align code enforcement to what is contained in the civil service job requirements and the statutory history here, along with the criminal procedure law, which gives the authority to carry firearms. It's never given it to code enforcement. It's never authorized those positions to use deadly force, to carry weapons, to have any sort of peace or police officer status. So there is really no reason for you to have a code provision on constables because that position does not exist here, and according to the case law, never will.
Do any of the board members have questions of Allison Matthews or Alan Schneider? None?
Yeah, I do. Thank you for the presentation, Allison. I think that clarified a lot of things for everyone in the village, so it's very much appreciated. But your very last words were, the village never had constables and never will. So what is the consequence of just leaving the language in the code as it is?
So there's no reason for you to have that language in the code. I think it's going to cause a lot of confusion. There are very strong feelings in this village about the difference between code enforcement and constable. So right now you have a clause in your, or I guess you say an article, and I'm sorry, there's feedback right here with the speaker. You technically have an article in your code that you were without any sort of authority to have in the first place. So that sort of thing really shouldn't be existing in your code.
The tangible consequence of leaving it there?
If you're not enforcing it, I suppose there would be no tangible consequence, but you have a provision of your code without any sort of authority.
Thanks.
So, question, what if a village or a municipality creates a position that is not approved by civil service? What are the consequences if a job is being done that hasn't been certified?
If you have a job that has not been approved by civil service and you place a person in that created job title, you make up a job title and you hire somebody and put somebody on the payroll, New York State civil service law, there is a section in civil service law that addresses that, and it is considered to be a misdemeanor on the part of the, if it's a village, on the part of the village board and the controller of the village or whoever is the authority to pay the person.
A misdemeanor.
It is a misdemeanor.
Okay.
Yes.
So we have a code in our books right now that if we hire somebody under that title, we're committing a misdemeanor without authority of the civil service office.
Yeah, correct.
So that's a consequence.
Sorry. Thank you, Allison. Outside of your job description.
Uh-oh.
But no, it would be a misdemeanor if we posted the job and then filled it, correct?
If you didn't do, if you went to civil service and you put a position duty statement into civil service, and civil service came back to you and said, this is the correct title, and the correct title is code enforcement officer. And instead of filling the position as code enforcement officer, the village board decided to fill the position as constables. And you hired people in those titles and put them on your payroll. The civil service department would disapprove the people on the payroll, send your village attorney a letter that these people are being paid illegally, the payroll is disapproved, and they must be removed immediately, and people hired in the correct title. If the village did not comply with that request, the civil service department would be required to turn the matter over to the district attorney. And that has happened before.
Trustee Hill, when I was asked to look in this before we retained Labor Council, part of my opinion was that whatever happened in 1980 when they moved Chapter 4 to Chapter 11 and bolstered code enforcement was specifically meant to replace Chapter 19 at that time because of the various lawsuits and requests of state legislative actors to approve that position, which was ultimately denied. And leaving it in the code, I believe, is what caused the confusion from 1980 to 2024 when, although fully vetted in front of this board with more than adequate counsel from both Mr. Schneider and Ms. Matthews, hey, we have this in the code, why don't we just hire a constable? If it's not there, that mistake can't ever happen again, which means the liability on this village, on everything that was discussed by both presenters, could no longer effectively happen to the good citizens of the Incorporated Village of Port Jeff.
So that said, one follow-up, can we just assume that when Chapter 4 became Chapter 11 and Chapter 11 superseded Chapter 19 by, based on court cases and whatnot, there was no ability to have Chapter 19 constables. So can we just assume that that board at that time just didn't take the steps to abolish that code when it was disallowed?
Maybe. It's the timing of it all, that is the likely progression. Again, there's no authority to fill those positions. Clearly, from 1990 to 2024, or 1980 to 2024, the village took to fill those positions to the detriment of the taxpayers and to the detriment of the good people who wore that uniform and the liability that would attach to them personally, because they thought they were hired to do a job they had no right or authority under New York state law to do.
Through no fault of their own.
No fault of their own, absolutely. And to perpetuate that mistake by allowing that to remain in the code it doesn't make plausible sense, in the sense that the case law is going to tell you that you're never getting that position, and that was part of the presentation by Ms. Matthews.
So is it fair to say that the action of removing the constable from the Port Jefferson Code is really just a cleanup activity to remedy something and prevent the sort of confusion that we're discussing here?
That is a theory. I don't have a time machine, so I don't know what happened in 1980, but the timing of it all, it being 1979, the request of then Senator Ken Laval to the state legislature for that position, the ultimate denial of that position, and then a year later, bolstering and moving and doing things to Chapter 4 to make it Chapter 11, that's a logical progression, but to say that with certainty.
And just to add on to that, you see from the history that you don't really know when this is going to pop up again, but it keeps popping up. So it pops up in the 60s when the village comes into being and becomes incorporated. Pops up in the 70s when they try and establish a constabulary. Pops up in the 90s in some other villages. Pops up again in 2004 with some other villages, and here we are in 2024, we're having the same conversation. So when that code provision stays there, well, if you don't use it, it's entirely possible that nothing will happen. It's there, and we can't predict down the road what someone else might do with it.
So if the board decides not to, or decides to eliminate this section of the code, and down the road sometime, something changes, and we're allowed to hire constables, we can reenact, or a future board can reenact a constable code.
Again, the slide that was on the board said there's a procedure for that. If the state law if the state decides to change the law in its infinite wisdom to allow constables in the various municipalities in the eastern towns and western towns, the procedure is application to Suffolk County Civil Service. Civil Service, if they approve that application, then goes to New York State Civil Service Commission. If approved at the New York State Civil Service position, then you need 2 acts of the legislature to add that position to the registry. I think it's also important to note, and I think Mr. Schneider mentioned it, those 3 eastern towns that have constables, they don't have a constabulatory. They don't have a unit of constables. They have a single constable, period. That's all they were authorized to have. So if there's an idea that any time in the future that Port Jeff is going to get a unit, a police force, a constable force, it's be in direct contradiction of the New York State Constitution, the Suffolk County Charter, civil service law, and the Suffolk County Policing District.
Right, but if that all happens,
Then yes, you can
then
put
we
it back
can
in the code.
reenact it. Thank you.
And just to follow up on that point, and Allison, if or even Alan, you might have insight on this. The three municipalities that do have those that title, that one person in that title, did they go through they had to go through the same process, even though their town had a bureau, correct?
Correct, they did. And if you, I don't know if you have Article 19 in front of you, but one of the different
But from what I understand, it possibly even happened last night, because I'm out on medical leave. I didn't go last night, so I don't know what happened. But apparently they were there as well. The running of this court, village court, I beg your pardon, has been the work of the code enforcement officers for over the last 20 years. Our union is addressing this legally as we speak, along with other issues that have been created. Up until now, did the village residents realize that they were getting $200 an hour to these off-duty personnel to be doing the court? Apparently now they do, because it was in the notes tonight. All right? Now, contrary to what you've been told, whereas perhaps we can't have constables, and perhaps that can't be the word that's used, we can certainly still do other things. And by the way, Ms. Matthews, wherever she is, thank you very much for the way you explained it. We can still do something where we can still, as code officers, carry weapons, and that's up to you. And keep in mind that we do a lot of other very important issues when we're out there. The fact that we meet the trains for the kids from St. Anthony's and Chaminade to make sure that the people who in the homeless shelter, they don't bother them. The fact that right here in this downstairs right here, we've gone on calls with people in the bathroom down here who have needles hanging out of their arm. We're the ones responding. The fact that Suffolk PD, and God bless them, they do the best they can. They deserve every penny they get. There's only so much that they can do, and there's only so many places they can be. And we have been, over these last 10 years, while I've been here, we've been helping them out. And with my 40 years of law enforcement experience, I've been able to help them out. Now for the trustees. There's a simple and easy way to solve this. You can give us this, if you want, you can give us the ability to still carry a gun. Call us whatever you want. I don't care if you call me a park ranger, code enforcement, whatever word you want to use. It doesn't matter to me. But you can still do that. All right. Biggest thing is this. What I don't want anyone to have happen at all, ever, is for the 2 units of Suffolk, and God bless them, who are out there, 610 and 607, for them to be somewhere else on Mount Sinai or somewhere else on a call, and God forbid an emergency comes up. God forbid something like happened in Wisconsin the other day with a school, and there's no one with a gun available to help. Whereas right now we have guns and we have police experience and police training, we can help. And the fact is, you have a number of, including me, retired police officers who know what they're doing and are willing to do it, but we have to have the tools to do it. And I know the people here are accustomed to having us help, and we want to help, but we need our gun to be able to do that. So you can call me whatever you want to call me, code officer, park ranger, whatever you want to call me. We can, with a gun, still help out there. And yes, of course, also issue summonses as well. But that's up to you, all right? And I only hope, God willing, that no one ever gets hurt out there when there are no guns, when 610 and 607 are not available. I hope no one ever gets hurt out there, because it'll look very badly on, quite honestly, on the board. It'll look badly for the people here in the village. So please, reconsider in terms of the guns, at least whatever you want to call us, code officer, whatever you want to call us, at least reconsider that. So at least the people who have the experience and training to be able to carry a gun to defend and help everyone here. Thank you.
Anyone else for public comment?
David Brengartner, 11 Meroke Trail, Port Jefferson, New York. Thank you, Mr. Hill, for asking your question. If it's not an issue to keep it on the books, then why remove it? Yes, for liability. Okay, my question in regards, don't make faces, please. Please. Okay? If we have a court officer that is hired outside of Incorporated Village, Port Jefferson, and they perform their duty in court, are they still at risk, and are they still liable for what takes place? If they have to use their weapon, do we not assume the responsibility for that officer? Maybe he is hired outside, and maybe he carries a secondary insurance. But don't tell me that we are not going to be civilly sued and be liable for that person's actions also. Okay? For a code officer who performed CPR, is he trained to do that in that position as a code officer? And if he does do that and saves a life or hurts somebody while doing that, is the liability still on the Incorporated Village of Port Jefferson? The answer is yes. everything that anybody does that is a member of this hired by Port Jefferson falls on the village liability for whatever they do in their performance of their duties. I agree with the fact of them being, they are not constables, they do not have peace officer status. I agree with that. I'm unsure of the statement made by, I'm sorry, your name now? Allison? By, we would never become constables. I don't understand that. If there is presence set by 3 villages and Fisher's Island, if law, why can't Incorporated Village petition for that through legislations if there's already presence set? I understand that the Incorporated Village wealth is not as high as wealth of the Hamptons, but we are state residents. I appreciate your time, and I hope and pray again that this is resolved by the majority of the village and not by the few. Thank you.
Would anyone else like to make a comment?
Okay.
Allison, would you?
No, Mayor, prior to that, I believe the clerk has a letter from the public to be read into the record.
Oh, okay. Thank you.
Part of the public comment.
Thank you. The recent decision by the Port Jefferson Village Board to disarm code officers is a commendable step toward responsible governance and a clearer understanding of law enforcement roles within our community. This move has understandably ignited public discourse, revealing a critical misconception, the conflation of firearms with authority. It's imperative to clarify that code officers tasked with upholding local ordinances and ensuring quality of life operate under a strictly defined legal framework. New York state law does not grant them the power to carry firearms. The notion that a weapon somehow amplifies their authority is erroneous and potentially dangerous. Introducing firearms into code enforcement scenarios unnecessarily escalates risk. It fosters an illusion of power that can lead to confrontations and undermine the essential nature of community-based code compliance. De-escalation tactics, conflict resolution, and proactive community engagement are far more effective tools for achieving the goals of code enforcement. The Village Board's decision wisely prioritizes these methods, fostering a safer environment for both residents and officers. By removing firearms from the equation, we encourage a less adversarial and more collaborative approach to code enforcement. This shift promotes trust and mutual respect, which are vital for a thriving community. Signed by Drew Biondo.
Thank you. Okay, do we have a motion to close the public hearing?
Public portion of the
Public
meeting.
portion of the public hearing.
Well, before we make that motion, at the last meeting, we had said that we were going to leave it open for the, I guess, until the January meeting. You know, we were talking about when we were going to hold this public hearing, and we said that we would hold it now, but we would leave it open till the next meeting. Does anybody else remember that, or am I mistaken?
I remember it, but what would be the reason for doing that? I don't mind either way, but what would be the reason for doing that?
You certainly have the right to, if anyone couldn't make the meeting tonight and you feel it's an important enough issue, which it may be, you could leave the public portion of the meeting to receive written comment to the village clerk for a period of time, 10 days, 30 days, January 5th, and at that point, the public portion of the meeting would be closed. There'll be no more verbal testimony, and obviously a decision will then come sometime thereafter.
I think it was in the context of it being close to the holiday, and folks might be gone, busy, last-minute shopping, family parties.
So
I would recommend a
procedurally,
motion, if the board's inclined, a motion to close the public portion of this meeting, leaving open written comment to the village clerk by whatever date the village board sees fit.
I concur. Would someone like to make a motion and pick a date?
30 days good, just given we're still in the holidays, so 10 days does not get us really out of here.
So why don't we align it with the next meeting date? Right, which is
I would do it maybe a week before the next meeting date, give the clerk time to process and the board to
Review.
put their eyes on those comments if we receive any.
so January
So January
1st January 1st is a Wednesday,
Right.
right? So what if we say the 3rd, a Friday? Because our next meeting is the 8th, so it gives us
I-
a full 5 days.
Forgive me, Mayor, I'm assuming the next meeting being a meeting where you vote, which would be the second meeting of the month. So a week prior to that meeting. Or
The 22nd. The 22nd of January, Mayor.
January 22nd?
Yes.
Okay, does someone want to make that motion?
So the 22nd is when we're meeting, so the Friday before the 17th?
We're meeting the 29th.
the meeting.
Oh, okay, all right. We're meeting the 29th, so we'll leave public written comments open until the 22nd of January
Yes.
To the village clerk.
to the village clerk. I'll make that motion.
Okay. Do we have a second?
Second.
All in favor?
Aye.
Motion carries. So the public comment section is closed. Allison, Alan, if you have any responses to some of the questions you've been hearing?
So it's going to be a little out of order, but I'll take the ones that relate to me, and then I'll turn it over to Mr. Schneider. So the last comment that was made on that you would never have constables, I had said that that was according to the case law, that that was an irrevocable transfer of authority of your police, to have your own police function over to the county pursuant to their charter. And both in the Nassau County context and in the Suffolk County context, the Court of Appeals has ruled that it's a one-time transfer, not to be taken back. There was a question about liability and liability for actions that are taken within job functions. So for anyone who has ever had to file an appeal with an insurance company, you know they love to disclaim and love to say that something isn't covered. So to the extent that someone is performing functions that are outside of their job description, that would give insurance a potential reason to disclaim, which means that the village and the residents would be on the hook for the full cost of any sort of litigation. There was also a comment about taking guns away. The village does not supply guns. It has actually allowed people who have the authorization pursuant to another outlet to bring their own gun to work. So there's no authority for the village to actually provide those weapons because it's not on the state registry. So that also poses a potential risk of liability because unlike a police department where they are distributing the weapons, there's procedures to test them to make sure they're functioning correctly. They own that equipment. That is not the case here. So the village is not taking them away. They're simply saying you're not bringing them with you to work. So I'll go through some of the comments here, and I'm going to let Mr. Schneider comment as well. So there was a comment about since the 80s, the constables have been receiving permission about working over the summer hours, so civil service knows what they're doing. So there's conflating two different concepts there, how many hours you can work with what you're actually doing. And I can let you speak to the actual process, but according to the position control list, everyone is a code enforcement officer. So unless civil service came in and does what's called a desk audit, where they investigate what that position is actually doing, they wouldn't uncover what the job duties are that are actually being performed, and that wouldn't happen as part of a request to work additional hours over the summer. There was a comment about bank drops, which I know you have some knowledge of what position should be performing that job duty.
So in relation to what the first gentleman spoke about, and in all due respect to him and what he does, I've been out of the personnel director job of Suffolk County for 6 years now, but during the prior 36 years that I was there, all jurisdictions submit to my former office a list of duties when they want to create a position, a new position, a new title, whatever it might be. They submit a statement of duties to the Civil Service Department. They list the duties, and from that list of duties, someone in my former department, a personnel analyst who is the liaison to, in this case, the Village of Port Jefferson, writes a job description based on exactly what was submitted to the Civil Service Department. So in the case of code enforcement officers, someone in a former administration in the Village of Port Jefferson at some time, when the title of code enforcement officer was first created, someone submitted a list of duties to the Civil Service Department, and what followed was the job specification that was up on the board that I read from, based on exactly what was submitted to the department. Those were the duties that the village described that code enforcement officers were going to do. Nothing more. Didn't mention anything about criminal procedure work. Didn't mention anything about bank drops, CPR work. Those were the duties, and Civil Service wrote that job description based on that. As far as the annual submission to Civil Service and Civil Service knowing exactly what the code enforcement officers are doing in Port Jeff, no one in the Civil Service Department knows.
Mr. Schneider, can you face the board and direct your comments to the board?
I'm sorry. No one in the Civil Service Department knows what a code enforcement officer is doing on the job, just like we don't know what anyone is doing in any of the 275 jurisdictions that we have oversight over. We rely on the jurisdictions to manage the towns, villages, school districts, etc., and their employees according to the job specifications that Civil Service has written and the employees work under. So what a employee in the Village of Port Jefferson does, what a code enforcement does, somebody sitting in the Civil Service Department, we have no idea what a village code enforcement officer is doing. What the gentleman mentioned about certifying the hours, that comes from the village office. Code enforcement officers are part-time, which means that they do not have to take a civil service test. They do not have to take the civil service exam for code enforcement officer. Code enforcement officer is a competitive job. If they work more than half the work week, they are considered to be full-time employees. If they are full-time employees, they are required to be appointed from a civil service list. The code enforcement officers in Port Jefferson have been reported to civil service as all part-time employees, which means that they work half the work week or less. Every year, the village is required to certify to the Department of Civil Service that all the code enforcement officers are working and have been working no more than half of the work week. That is what the gentleman is referring to. We get certifications from all our jurisdictions regarding part-time employees to make sure they are still in the non-competitive class by working less than half the work week. That puts them out of the competitive class into the non-competitive class, making them exempt from having to take an exam and being appointed from a civil service list. So what the gentleman was referring to had absolutely nothing to do with the duties. Civil service does not know what the code enforcement officers are doing in Port Jeff.
Mr. Snyder,
As far as
I want to address what's going to be your next comment about the bank runs.
yes,
Just in following on what you're saying, with the approval of the village board, we recently sought the approval from civil service and received that approval for a full-time senior code enforcement officer. We have filled that position, and that person is currently making the necessary bank runs.
okay.
And to addressing the court officer situation, I want the public to understand a couple things. One, it's not $200 an hour. It's $200 per appearance per night, whether it's 1 hour or 5 hours. The second thing is that we still rely on our code enforcement officers to provide the building security and move the people around the courtroom as they always did. It was their request to be protected. The difference being is the approval through the New York State Uniform Court System to use certified New York State court officers, because they are actually authorized. In the event they have to draw their firearm, the village will have adequate insurance coverage, and that liability would be covered as long as they're acting within the scope of their job description. Whereas, if you're acting outside the scope, or you do not have the statutory authority to carry, and you draw your weapon, the insurance company will disclaim, creating liability on behalf of the village to be covered by the taxpayer, not to mention personal liability on the individual who had to draw that firearm. And that was the impetus at the start of all of this, is to protect, and a fiduciary responsibility to protect both the men and women who go out and do the job of public safety without the knowledge of every time they went out, they put themselves in harm's way financially, and every taxpayer in this village. It wouldn't be outlandish for a wrongful death suit on a firearm to be a $13 million settlement, which means every taxable parcel in this village is going to pay $6,000 to help fund that. Whereas, with the proper statutory authority, the adequate insurance is in place, therefore, that burden, that liability is now covered.
I just want to add to that. Suffolk County has a outstanding police force, but occasionally a police officer uses his gun and some innocent person gets shot or killed inadvertently. Very unfortunate, but inevitably it leads to a multi-million lawsuit and either a settlement or an eventual payment of that lawsuit. So a $13 million lawsuit in Suffolk County with 1.4 million taxpayers would amount to $9 a household. Quite a difference from Port Jefferson Village $6,000 a household. So, in that instance where that happens in a county with that kind of liability, it's fairly easy for the taxpayers to absorb that. But and the county does have liability insurance as well. But for whatever the liability insurance doesn't pick up, it's easily absorbed by the taxpayers. Okay.
Mayor, assuming there's no other comments from our presenters and the board doesn't have any questions, we would need a motion to hold this hearing open till the January 29th meeting of the Village Board of Trustees.
Do we have a motion to leave the hearing open?
I'll make the motion. Second.
All in favor?
Aye.
Okay, motion carries. Thank you, Allison. Thank you, Alan. Okay, next up we have our public comment section for the meeting tonight. So I'm hearing we're having some sound issues, so if those, do we know that it's good? Okay. All right, thank you. Anyone who has a public comment, come on up, state your name and your address.
My name is Drew Sora, 2 Stern Drive. Just wanted to comment on, so sorry to everyone who's here for the golf. I wanted to comment one more thing on our incredible men and women who serve in this village and who serve us as code enforcement officers, to just outline to everyone who's here tonight. Sorry, I can't look back at you or I think I'm going to get yelled at. To everyone who's here for the first time tonight, if this is your first meeting, I'm so sorry that you've been here for such an egregious amount of time. Sometimes this happens, but ultimately, I just wanted to lay out that the bulk of the previous issue for our code enforcement officers was not entirely about them being able to carry firearms or not. There was another major part of that issue where our former code enforcement chief, multiple more code enforcement officers came and spoke here last month, and there were 3 statements released by 3 separate trustees who are sitting on the board today, and there was a clear miscommunication and a mistruth with the date of when the incident occurred from Mayor Shepro and the severity of the incident. That was told to trustees, and that was told to residents, and that was told to others. That is why so many people are also standing up and are speaking about this issue, because I know there are a lot of people who maybe they're here for the first time tonight to talk about something that's important for them, and I completely support that. But this code enforcement issue is also incredibly important because it's not just about the issue itself, it's about how there has been multiple mistruths that I outlined in the previous meeting that I'd love to outline to anyone else who would love to hear them personally and everything from Mayor Shepro directly. And that is happening multiple times. And I want to let everyone know that this is not an accident, but this is a pattern of misrepresentations of truth to the public and to other trustees that has made me lose a lot of faith in what we're all here to do tonight, which is make sure that we're being heard. And I really want to make sure everyone who's here for their issue tonight is heard on what they believe in, and that there's not a preconceived notion in some people's minds to vote how they are already planning to vote. I want to make sure that everyone's voices are heard tonight, because I know that there have been times where a lot of people have felt like their voices have not been heard. It has happened multiple times before. It'll probably happen multiple times again in the future. But please listen to everyone's opinions tonight. There are students here, parents here who have taken an enormous amount of time out of their day, probably more than they planned, to be here tonight to speak to you and make their case heard. So please listen to them. Thank you so much.
Any other public comment?
Good evening, Karen Sullivan, 66 Soundview Drive. I'm not going to talk about code enforcement, but I just wanted to formally introduce myself and get on record who I am. I am now a proud owner of a business on East Main Street, 146 East Main, the Wellness Stop. We opened in April officially. Took residency in March, and I wanted to really formally introduce myself because most of you, with the exception of Kyle Hill, Trustee Hill, you've never stepped foot in my store. And I feel that we need to do better as a village. So today, I finally had my interview with Chairperson Stapleton and Trustee Hill to potentially sit on the Public Safety Committee as well. It's to my knowledge now that there are other residents that are interested in filling that open seat, which I think is absolutely fantastic. I think it's wonderful that besides myself, that there are other residents that do want to step up and participate and volunteer. So if I don't get appointed to that position, that's okay. But there's so many other ways that I can help and support the village besides being a business owner. I've lived here for over 30 years. I've sat on multiple boards for the school district. I was helpful in reenacting the special ed PTA as well. So one of the things that I wanted to just really say to all of you is that I think that we really need to make a stronger effort for you, who were all elected by us, and all the chair people that are now running these committees, to make a point in 2025 to show your faces in the businesses down in Port Jefferson. You don't have to shop in our stores, you don't have to support the store, but we would love that as well. But I think you need to step in and just introduce yourself, give all your contact information, say hello, and also say, hey, how can I help you? What are you concerned about? I have concerns now that I'm a business owner on East Main Street. That's why I want to hopefully sit on the Public Safety Committee. I have concerns about speeding. I have concerns about safety. I have concerns about crime. And that really started when the slashing, unfortunately, happened here outside the Village Center. And I did speak to Mayor Shepro about that in June at Meet the Candidates. That was so alarming and tragic what happened to that man, and that his wife had to witness, and their friend as well. The wife now is actually a customer of mine in the store, so we've had private conversations about that incident, and it's been so PTSD specific for her. So my point of coming up here and speaking is I feel that there is a disconnect. I feel that that particular situation, and I did talk to Mayor Shepro about it, the stores should have gone into a lockdown. We should have used the red alert system, because God forbid that man, if he had decided, because he was fleeing at that time, if he had decided to come down East Main Street, he could have ducked into my store. And then what would I have done? Because again, and that could happen even if there wasn't a slashing. I now have panic buttons under my register, and I am going to say on public record, and this is the first time that I am actually divulging this publicly, but I am a firearm owner, and I do have my concealed carry, and I will plan on probably concealing and carrying my weapon in my store, because I am concerned about my safety. We are living in a time that is extremely volatile and unstable. So whatever you decide, I do respect the decision of the board as far as code enforcement goes, but I think that we need to really try to come together and just let's show our faces more in the community and really listen to what the stores are really looking for. So, and the other thing that I did notice is last night when I was looking for the red alert, because I wanted to make sure that I was signed up for that, I couldn't find it. It took me 20 minutes to find it. It's kind of buried in the website. I think it should be listed as a separate tab underneath the residence section. So there's like a quick link to that, so every resident knows really how to find it. So thank you so much for your time.
Can we speak about health now? Paul Peterson, 43 Jefferson Landing Circle. Thank you for giving me the opportunity to speak tonight. I'm a longtime resident of Port Jeff Village. Moved out of the village when I got married, and I recently moved back into the village, and I gladly paid
a lot from my house for the amenities that it offers. As a member of the Port Jefferson Country Club and a village resident of the village, I think there's certain things that need to be adopted. One, village residents must always pay 60% of what non-residents pay. Two, Port Jefferson golfers aged 12 through 18 must be allowed to join the country club. Three, no Port Jefferson village resident will have to pay initiation fees to join the club. In reference to the newsletter, it was stated that the Board of Governors had done an admirable job working on the course. My issue with the Board of Governors is as follows. When tasked with deciding the rates for the 2025 golf season, they left the village residents out of it. They created an initiation rate for Port Jeff residents. And remember, this is our course. They wanted to do away with juniors joining the club unless a parent joined as well. They wanted to reduce the discount that Port Jefferson village residents have enjoyed for years. Based on those decisions, the Board of Governors have showed itself to be unreliable to lead. We must realign that board. Out of the total 7 members, 5 must be Port Jeff village residents, and the president must be a village resident. As it stands now, the majority of that board are non-residents. I know tonight is not the night for each one of you to give your opinions. I do know that there's an election in June, and I won't be voting for anyone who disagrees with the above. Thanks.
My name is Grant Conley, and I live at 101 Jane Avenue. Like many members of the community, I was confused and also irritated with the rate structure that was proposed on December the 4th. Why are we here on December 18th still hashing out this new rate structure that is set to be put in place in less than 2 weeks? The rate structure of the upcoming golf season was always presented in early fall. Now, with the most dramatic changes proposed in decades, it only became public in December. And I guess my question first would be, is who participated in the creating of the rate structure that was proposed to the Board of Trustees on December 4th? Now, I don't know if this is the form I can ask the question and have it answered directly, but that would be my first question.
What's the rule, Attorney?
Public comment, Mayor, based on the title and what generally happens at a public comment. However, once public comment is over, there's nothing stopping the board from saying its piece or addressing whatever needs to be addressed. But a formal question and answer from resident to board, right back to that, and that back and forth is discouraged during a public comment portion. But again, it's for the best interest of getting the appropriate answer. And if it can't be answered at that time quickly by the board after public comment, then we ask you to put your comment or question in writing to the village clerk to be addressed at a later date.
Okay, and I just asked the question because I want to best understand where this new rate structure is, what the origin of it. Is it the Board of Governors? Is it the CCMAC? Is it the manager of the club? So I think it's important for us all in the community to best understand where this new rate structure was coming from, because it was alarming, and to have it proposed so late in the game is also a bit upsetting. And there's also, and when we look at some comments that were made online by members of the CCMAC, there's contradictions to what was sent out by the country club in terms of who was piecing together this rate structure. And then the second item that I want to talk about, which is near and dear to my heart, is the junior membership. Just reiterating what was said earlier, the junior membership must remain unchanged. The junior membership has been eroded enough over the past few years by the CCMAC. This has been done by pushing back start times from where they once were, further restricting days of play, establishing leagues where juniors are not permitted to play, and removing their ability to take out guests, a privilege they enjoyed just a few years ago. Stop removing the rights of our young players who are the future of the club. And also, the false narrative that they are somehow a liability and their behavior is anything less than exemplary also must stop. I repeat, stop perpetuating lies about our children in order to push through an agenda to make this Port Jeff Country Club a more exclusive club that feels more exclusive and luxurious to people up there for some reason or another. They want juniors out. 2 years ago, the CCMA attempted to push juniors out by increasing their rates by over 200%. We pushed back in this very room 2 years ago against that proposal, while the other members were enjoying a 6 to 8% increase. That attempt failed, and it failed because the members of our village value our children and the resources that Port Jefferson avails to them. We will never back down against people who look to take opportunities from our kids in Port Jefferson, period. The last thing that I also wanted to just touch on was the elimination of the social membership. Since I first became involved in the club 20 years ago, there's been a social membership, and now there's a proposal to eliminate it. And the proposal to eliminate it was, the reasoning was something about it being confusing, which I don't know what's so confusing about a social membership. And it's, once again, to me, looks a lot like an attempt to restrict this opportunities for people to come and enjoy the club who might not otherwise be able to do so. And I do not know how removing a social membership in any way helps the members of our community. And that's all I have to say. Thank you.
Well said, Grant. Well said. My name is John Riley, Jr. I live at 109 Rustic Road in Port Jeff. I just want to touch upon what Grant said and just look at some just raw data that I got my hands on the new rate structure. I believe this is accurate. Is this accurate in the packet?
It's in the packet.
Yeah.
It's what's being
Yes, I'm seeing it for the first time tonight, so I didn't do the exact calculations, but it looks like, it's going to look like you reinstated the junior membership, and I appreciate that. However, there is massive restrictions. Now they cannot play until after 2 o'clock every day of the week, and you are assessing them the same as a full-time member. You are also, their dining credit is the same as a full-time member. They can only play at peak sunshine, late June, they can play less than 50%. Late fall, early spring, they can play less than 35. It's close to 25% of the time, based on sunset and sunrise times. Less than 50% at peak, almost 25% in late fall and early spring. Yet they're getting fully assessed, almost over $1,100 in assessment and food credit. For what, a 14-year-old girl? So, please reconsider that. It just mathematically doesn't seem fair. Thank you.
Matthew Franco, 5 Avon Drive, Port Jefferson, New York. Good evening, Mayor Shepro, esteemed trustees. It's tough to follow John and Grant because they are very passionate about this, because they have children that are involved. I don't really have any skin in the game because my son and my daughters don't play golf, and they're no longer junior members. But I find it offensive, and I apologize for using those terms, that we are going to charge the junior members a $725 club assessment, a $400 dining credit. And it's interesting because I spoke to Tom and I said, and we're still going to restrict their ability to play at the course. You can't have both sides of this argument. If you want to make them part of the course and say that they have to take on a financial responsibility, you can't then take away their ability to use the course. Well, then if you're going to charge them that much money, then give them the access to the course whenever they want, because you're making them equal to us. Now, children in our community should never, ever be assessed a club assessment. We've never done that in the past. It's such a insignificant dollar amount. As Tom told me earlier this evening, we are going to lose 20 junior members approximately. So that will leave us about 31 junior members. The number we're talking about is about $22,000. We're causing a controversy in our village where we should have harmony. We're causing disharmony. Over $20,000? For what reason? The children in our community should never, ever be assessed like we're assessed. That makes no sense. They don't have the income levels that we have. Their parents might not be able. We're putting an additional burden on parents that's unnecessary. It does not need to be done. It makes no sense to me. So if we're going to do that, put this assessment on them, are we going to relieve them from being able to have to start at 2 o'clock in the afternoon? Should they have access to the course whenever we have access to the course? I believe that we should go back somewhat in time and give them additional time on the course and not assess them the assessment. It makes no sense. The food cost it's not fair to the children. It's not fair to their parents. This was never done in the past. Past practice and precedent should have some meaning in our village. As a community, we should say to ourselves, what have we done to other people's children? What do we do to our children? So now we're going to pass this additional burden onto the next group of children that are going to come play golf at our club? That's unreasonable. I think that we should use past precedent and past practice and best practice for our children. And taxing them like you're going to tax an adult is unconscionable. So, thank you for your time. I appreciate all your help. I know this is not an easy thing for you, and I appreciate every one of you and how hard you're working for us. But this is an unacceptable addendum to this change to this fee structure here. The rest of the structure, we're adults. We can take care of that. The children shouldn't have to suffer. Thank you for your time. Pardon me, one more thing. It's nice to look around the room, and I'm going to turn around and see fellow residents here. What I don't see here are the non-residents on the Board of Governors. Where are they today? This is their plan. They should be here defending it, but they're not, because they don't live here. They're not invested in our community. They want to use our asset and then go home, cause a problem, and not be here to be part of the solution. These people here are residents of the village. We're part of the solution. Thank you.
My name is Joseph Joyner. I live on 53 Bell Circle, Port Jefferson, New York. I'd just like to say that I joined Port Jeff Country Club in 2019 as a junior member. And initially, when I first joined, we only experienced small restrictions, only playing after 2 p.m. on Saturdays. We had a decently cheap rate, and my parents let me join because it was one of the best value pretty much on Long Island. It was an amazing course, great value. And as I've played across the past 5 years, every single consecutive year, juniors have been cut at more and more and more. Initially, 2 years ago, juniors, they, as Grant mentioned, they tried to jack up the rates 300%. And when we came and talked to them, the compromise we decided on was that juniors could no longer take guests, which is still in effect today. Some of the other restrictions that are mentioned in here, like juniors having to pay on cart path days, just don't make sense. Most of these kids aren't even old enough to drive yet. They can't take a cart even if they wanted. Yet you're going to be charging them money for a resource that they couldn't use. And I've made countless memories with these guys across the past few years. We spend summers out there every single day, 5 days a week, working hard on the golf course, preparing. And these restrictions, like not being able to play before 2 p.m., will prevent these kids from getting the practice that they really need. We have golfers who are looking to make it to states next year and make a run for the next 3 years to really make a change in Port Jeff, and yet they might not have the ability to play for the time that they really need to improve and get out there. So these changes are just limiting the amount that Port Jeff can really help the youth, and it's sending a message that Port Jeff doesn't want the youth to play golf. It's sending the message that Port Jeff is trying to prevent the youth from getting out on the course, and it's just not the message I think we should be sending.
everyone. I'm Seamus McEwen. I live on 103 Willis Avenue here in Port Jeff. I'm a recent graduate of Port Jeff High School. I was a four-year player on the Port Jeff golf team, and I've been a junior member this year will be my last year of eligibility for that. But I've been a junior member for around 4 or 5 years. I kind of just want to go off of what Joseph said and kind of just describe like the memories that I've made on the golf course with these guys, a lot of these people in this room, adults, people in this community that I've made connections with through this golf course and things like that. They've been very valuable for me. I've learned a lot of lessons out on the golf course, like morally. I've met people, I've had experiences, I've made friends. I think overall it's been a huge positive in my life, and it's something that I would love for like the youth of my town, like going forward, to be able to have that shared experience. One thing I will say throughout these years of playing golf up there, a lot of the I think this like kind of the root of this issue is we have a lot of people who are in power at the golf course who really kind of just discriminate against young people in general, whether they know it or not, whether they're purposely doing it or not. So I really think the root of this issue is people in power who tend to be like elderly people. There are people who are discriminatory towards the junior members and younger people. Thank you.
How you doing? Pete Poten, 21 Second Avenue. Couple things I heard tonight that I wasn't aware of that our board, Pete Poten, 21 Second Avenue, thanks. How can people that don't live in this village have any say as to what goes on here? Mind-boggling to me. Mind-boggling. That has to change. And anyone in this room that thinks it's okay to discourage these kids, especially in this day and age, how hard it is to grow up, take away something positive, you should all be ashamed of yourself, wherever this idea is coming from. Unbelievable. Unbelievable to me. These kids have a tough enough time growing up now, and we're going to discourage positive things and take it away? Ashamed of yourself, whoever's bringing this shit up.
Sorry. David Brengartner, 11 Roki Trail, Port Jefferson, New York. I graduated in 1987 from Port Jefferson. I played on Port Jefferson's golf course, on their golf course and on the golf team from Port Jefferson. I was granted the privilege to play for them. I became a member in the Port Jefferson Country Club, as every one of these youths may become. They are our future. They are our future in our high schools. Why are they not our future in our country club? Okay, I may not be as knowledgeable in regards to the assessment as others are, but if a player is a resident and he's eligible to join the country club, he should be not restricted to times of play. If he's a full-time he should be able to play Monday through Sunday all the way through on any given time. If he's a Monday to Friday, he should be able to play Monday to Friday, and given the same awards as that person on Monday to Friday after 2 o'clock on a Saturday or Sunday. They should not be restricted if they are able to join the country club, which as residents they should. You know, they are our future in our country club, you know, whether they become residents or they don't. If they've played the course, they're going to want to play the course as non-residents also if they stay within inside of Suffolk. So again, they believe they should be able to join the country club on all levels. Thank you.
Craig Stanton, 107 Beach Street, Port Jefferson. I'll be very brief because I put everything in writing, but I am in favor of junior memberships. I am not in favor of club assessments being assessed on junior members. I'm not in favor of the more restrictive tee times for junior members. My wife and I do not play golf. My son, through a junior membership, learned to play golf. He is now pursuing a very healthy pursuit, no help to us, and he also made the Port Jeff golf team because of that. Okay, and we do not play golf. So I don't want to be required to join. I want kids to be able to join without their parents. If parents join, that's great, but they should not be required. And very quickly, the word liability was brought up by the golf manager last time. I think that was very irresponsible. You know, we don't talk about if 4 15-year-olds get together, play basketball on the PJ basketball courts or tennis on the tennis courts, we don't talk about liability. All of a sudden, we're talking about liability on the golf course. Okay, it's a non-issue. Okay, please don't be swayed by that. Thank you for listening.
Thank you for the public discourse. Oh, do we have one more? Okay.
My name is John Boswell. I've lived in Port Jefferson for just about 50 years now. I reside on Hill Drive. I strongly oppose these changes. These are directly against what we're trying to encourage in our community, bringing our children in, and these changes will impact that. As well as we're a week away from Christmas. We're here talking about this, but as mentioned earlier, no one that's bringing these changes is here. That board needs to be, it's not your doings, but that does need to be looked at as we move forward. But I strongly oppose these changes. I plan on, when I retire in a couple of years, I plan on joining the course, building relationships with people that I know and I trust and like. This would discourage that. Thank you.
Any other public comment? Okay. Thank you all for your comments. Extremely important to hear directly from residents and members and non-members. So you've given us, I think, a lot to think about, and that's all I'll say right now. But we do have the new rate sheet to look at tonight during the agenda portion of our resolution portion of our meeting. So with that said, I think next on our agenda, we have a motion to close the public comment section. Do we have a second? All in favor? Okay, motion carries. All right, now, Clerk Perillo, we look to you, or to Attorney Mann, okay, to you to start the action agenda items.
By the way.
Is my mic working?
No way, it was 73.
I'm not sure you folks want to leave.
Seriously, you guys are such welchers.
No, I'm happy.
Hey, Jeff?
have a microphone here if you want to use it.
Testing, one.
It's
Thank you. That's fine. Check.
Carl, it's red. Is the battery slow? Okay. If it goes out, red is, and we'll switch it back. Sorry.
I'm gonna wait for everybody to shuffle out.
Sylvia, when you're ready to start. Where's Marin? Excuse me. Are we ready, Mayor? We're ready. Trustee Giuliano, are we ready to start?
I had asked the question if I could speak with him. He said yes. I'm sorry. That took 1 minute of your time. 1 minute. I apologize. 1 minute. Okay, we're ready.
Thank you. With that, we'll go to resolution number 121824, resolution approving the attached minutes of the November 20th, 2024 and December 4th, 2024 meetings of the Board of Trustees of the Village of Port Jefferson. May I have a motion?
Motion.
Second? Thank you. All in favor?
Aye.
Thank you. Resolution number 121824, resolution amending resolution number 15112024, approved at the November 20th, 2024 agenda meeting of the Board of Trustees to update the name of the approved proposer for plowing and removal of snow to B&B Maintenance Services, Inc. May I have a motion?
Motion?
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 121824, resolution approving the attached municipal resolution required for the New York State Consolidated Funding Application number 144185 regarding the Restore New York Communities Initiative Municipal Grant Round 9 for the proposed project by the Gito Group at 1506 and 1510-1512 Main Street, Port Jefferson, New York, 11777. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 121824, resolution approving the attached resolution recommended by Assessor D'Amato, authorizing the village assessor to include IRA, annuity, tax-exempt interest and dividends into a senior citizen's income when determining eligibility for a senior real property tax exemption. May I have a motion?
Motion.
Second?
Second.
All in favor?
Can we discuss this a little bit?
Sure.
Are there projections on how much this would increase revenue for the village? Or, yeah. How much would this increase taxes on Port Jeff seniors?
That would be entirely dependent upon the individual exemption that's been authorized, and I don't have that analysis.
There has to be a projection, though, because we're not doing this for fun.
I don't have that analysis. I'm sorry, trustee.
Is it absolutely necessary that this gets voted on tonight, then?
That would be a decision for the board.
But, sorry, is there a budget implication for not voting on this tonight?
Hang on. Does it make sense? For me, there's not enough detail here. So is it the full amount of an IRA, or is it just the interest income that's coming off of that IRA? You know, that I think we need a little more information on this one before we actually close it out.
That's entirely up to the board to table this resolution.
I'd like to motion to table this, then.
Okay, second.
Discussion? Did you all read the resolution? And what did that reveal to you? Not enough information? The resolution approving the attached resolution. And if we had a question about this for the assessor? probably would have gotten back to us. I don't mind tabling it at all, really. I don't know that there's a time frame on it, but I really, it would be helpful, like if there's a question about something, we can leave it off the agenda if you have a question that can't be answered on time. You know, so that's a fair enough thing to do.
I agree with you completely, but the draft agenda used to be sent out on Fridays, and it seems it's getting closer and closer to the Wednesday meeting, and forgive me, I just didn't manage to be able to do it this time.
So I'm going to read this resolution out loud, if that's okay. Maybe it'll clear it up a little bit. To authorize the village assessor to include distributions from individual retirement accounts and individual retirement annuity distributions in a senior's federal adjusted gross income as part of a senior's income for purposes of a senior tax exemption application in conjunction with tax exempt interest and dividends. So this is to include the income so that it is higher so that the exemption is approved. Does that make sense, Treasurer Gafka? Am I reading that right?
Yes, that makes sense.
The Board of Trustees of the Incorporated Village of Port Jefferson, duly convened pursuant to state and local law, does hereby declare as follows. Whereas New York State has provided the local governments to opt to include individual retirement account payments, individual annuity payments, and tax-exempt interest and dividends in the income analysis of seniors applying for senior real estate tax exemption pursuant to the New York State real property law, tax law. And whereas the Village of Port Jefferson is mindful of the tax burden imposed on other residents when tax exemptions are granted, and the need for fairness in applying exemptions based on the actual income being received by a taxpayer when requesting an exemption, now therefore be it resolved by the Village Board of Trustees that, effective beginning with the 2025 assessment rolls, the village assessor is hereby authorized to include the individual retirement account payments, individual retirement annuity payments, and tax-exempt interest and dividends of a senior exemption applicant in the senior's income analysis for determining exemption eligibility. And this resolution shall take effect immediately. So,
Mayor, if I could just to say that, what I think would be English. The state has authorized the local municipalities to include all income of anyone applying for a senior exemption, including the items you artfully read off. In the past, some people, when applying for exemptions, don't fully divulge all of their income, which may not qualify them. So if Trustee Hill, if this answers your question, the likelihood of financial liability to the village, it's likely that less senior exemptions will be granted, which will relieve the tax burden across the board to the residents, and a possible increase in money coming back to the village based on including all income that a senior may derive, whether it be from an IRA or these other sources, if that helps. If it doesn't, I try.
So I have one more question. It was not so much the components of it that I was wondering about, but is this consistent with, say, your 1040 filing? Are we bringing this in line with other government tax regulations, or is it distinct?
It seems that the state has said it's up to you, municipality, to include these other sources of income or not.
but it is in accordance with New York State real property tax law.
Sure.
Tax law. Okay. All right. Sorry that I was short, if I was, but did that help?
Yeah, no, that is helpful, and that the way the attorney described it is what I thought was going on, but I think it would be really helpful to know what is the actual tax revenue that we're expecting so that we can be upfront with our senior citizens and how much their taxes are going to go up, and what is the benefit for the rest of the community for that instance.
No, I think it's the opposite.
If fewer seniors are eligible for that tax break, their taxes go up.
No, they file exemptions.
But it's passing this resolution to make it harder for them to get that exemption because we're counting more of their money that they're getting as income.
Well, I think we need the assessor to explain that one too, because that's his expertise and not mine.
Okay.
So
There's
do
a
we have,
motion and a second to table.
all in favor?
Aye.
Mm-hmm.
Table. Aye.
Motion carries.
Resolution number 5121824, resolution approving the attached memorandum of understanding between the Village of Port Jefferson and Chase Bank regarding a shared automobile parking stall agreement and authorizing Mayor Shepro to sign the memorandum of understanding between the Village of Port Jefferson and Chase Bank. May I have a motion?
Is it me? Motion, sorry. All in favor?
Thank you. Resolution number 6121824, resolution approving the attached proposal submitted by Day Smart Recreation for the upgrade of Rec Pro software at the Village Center and authorizing Recreation Center Manager Renee Lemmerman to sign the agreement between the Village of Port Jefferson and Day Smart Recreation. May I have a motion?
Motion.
Do we have a second?
Second.
All in favor?
Aye.
Thank you. Resolution number 7121824, resolution authorizing the rehiring of part-time Fire Marshal Todd Stumpf at an hourly wage rate of $28.65 per hour, effective December 26th, 2024. May I have a motion?
Motion.
Second.
All in favor?
Aye.
Thank you. Resolution number 8121824, resolution approving the following. Whereas the Village of Port Jefferson is desirous of ensuring that the integrity of the village court proceedings are adequately protected and secure, and an application has been made to and approved by the New York State Unified Court System for the hiring on a per diem, as-needed basis of independent contractor court officers from the New York State Unified Court System effective December 3rd, 2024, for 2 officers per court date at a pay rate of $200 per officer per appearance, and said court officers will be used to supplement justice court appearance operations, which continue to be provided by village code enforcement officers. May I have a motion?
Motion for the purpose of discussion.
Second?
Second.
Uh,
Discussion?
So I just want to understand, so we've held court twice now, but now we're authorizing the village to pay for these court officers. So how did we have the authority to pay the court officers the last 2 court sessions?
We haven't paid them yet, trustee.
I see. So what happens if this doesn't pass?
Then we owe them the money on a quantum merit basis for services they provided. And this will happen from time to time, in government, where actions needed to be taken in order to allow government to function, and then a retroactive resolution passes. I'm sure you're familiar from your time on the Hill. This is similar to that, where court operations were going to cease unless we did something to make sure that our court officers felt safe during those proceedings, and this was the solution.
Okay, and for clarity, the judge is requesting this?
No. Can I talk about it? Or should we do it in exec? We should do that in executive session because it was part of dealings with the union.
Okay.
Just one question, and I think we could talk about this now. By hiring these court officers, we're still employing the same amount of code officers.
The When to Work app that allows the officers to work is still in effect, and the same number of officers can sign up to work. The Justice Court, that's why we made it clear in the resolution, the court officers are meant to supplement to secure court operations. For example, a judge may say you're in contempt of court. Officer, put them in custody. We don't have peace officers to do that. That's one example of probably 100 I can rattle off. But as I said, the remainder of that discussion, if Kyle wants to have that in executive session, we can.
Thank you.
So just jumping off that answer then, what would we have done like 4 months ago?
That is the point.
Okay.
It's not a problem till it's a problem, trustee.
Well, we have a motion and a second. All in favor?
So
I believe it's a motion to table for later in the evening, and because Trustee Hill wants executive session.
Okay. Anybody want to make a motion to table? Do we have a second?
I'll second.
All in favor?
From the table over here, we only heard 2 ayes.
Aye.
Sorry, aye. Sorry.
Thank you. Resolution number 9-121824, resolution approving the attendance of Executive Board Member Mayor Lauren Shepro at the 2025 Executive Board meetings of the Suffolk County Village Officials Association. May I have a motion?
I'll make a motion, and I also want to congratulate you.
Thank you, Bob.
I'll second the motion and ditto the congratulations.
Thank you, Stan. All in favor?
Aye.
Aye.
Thank you. Thank you. That's, I'm honored to do that. I'll just make a quick comment on this, that I've been attending several of their board meetings as invited, and also a bunch of their events, and I attended one with Trustee Giuliano several months back, and everything that the Suffolk County Village officials do is relevant, Officials Association does, is relevant to what we do sitting at this table. And every time I'm in attendance at one of their functions, I learn a lot. We share ideas, we share experiences, and we network to the great effect of having someone else's experience lent to ours. So I'm grateful for this, and I hope to bring back more resources to this board and this community as well.
Thank you. Resolution number 10-121824, resolution authorizing Treasurer Gafka to perform attached budget amendment number 65 to decrease the overall general fund budget by $158,000, detailed as attached. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Aye.
Thank you. Resolution number 11-121824, resolution authorizing Treasurer Gafka to perform attached budget amendment number 66, decreasing the overall Port Jefferson Country Club fund budget by $210,000 per the attached breakdown. May I have a motion?
Motion.
Second? Thank you.
Any questions? All in favor?
Aye.
Thank you. Resolution number 12-121824, resolution authorizing Treasurer Gafka to create a new capital expense line item to be known as H51102051, Highway Capital Paving Project, SCWA. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 13-121824, resolution authorizing Treasurer Gafka to perform attached budget amendment number 70 to record the SCWA paving contribution by increasing anticipated revenues by $474,224.81 for line item A, 2770, miscellaneous revenue, and increasing appropriations by $474,224.81 for line item A, 9950.9, interfund transfer. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 14-121824, resolution authorizing Treasurer Gafka to perform attached budget amendment number 71, increasing anticipated revenues from line item H, 5031, interfund transfer by $474,224.81, and increasing appropriations for line item H, 51102051, Highway Capital Paving Projects, SCWA, by $474,224.81. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 15-121824, resolution authorizing Treasurer Gafka to perform attached budget amendment number 72, increasing anticipated revenues by $28,000 for line item A, 5031, interfund transfer, and increasing appropriations by $28,000 for line item A, 9950.9, interfund transfer. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 16-121824, resolution authorizing Treasurer Gafka to perform attached budget amendment number 73, decreasing anticipated revenues by $28,000 for line item H3089, other government aid, and increasing anticipated revenue by $28,000 for line item H5031, interfund transfer. May I have a motion?
Motion.
And a second.
Second.
All in favor?
Aye.
Thank you. Resolution number 17-121824, resolution authorizing Treasurer Gafka to perform attached budget transfer number 21, reallocating unexpended ARPA funds, decreasing appropriations by $2,580.43 for line item H714522, Village Center skating rink equipment, and increasing appropriations by $2,580.43 for line item H9950.9, interfund transfer. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 18-121824, resolution authorizing Treasurer Gafka to perform attached budget amendment number 74, allocating unexpended ARPA funds toward the purchase of a sign-making machine and increasing anticipated revenues by $2,580.43 for line item A, 5031 interfund transfer, and increasing appropriations by $2,580.43 for line item A, 5110.2 highway equipment. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 19-121824, resolution eliminating the social and hole-in-one membership rate classes at the Port Jefferson Country Club for the April 2025 to March 2026 season. May I have a motion?
Motion.
Second?
Second.
Second.
Yeah, let's discuss it.
Mayor, for efficiency, should we call all three resolutions and have one global discussion?
Sure, let's do that.
Yes. Would you call all three resolutions?
Resolution number 20-121824, all four. Resolution establishing the continuation of the Golden Full, Golden Mod, and Platinum Full membership rate classes for members already in the Golden Full, Golden Mod, and Platinum Full membership rate classes at the Port Jefferson Country Club. Motion?
Motion.
Second?
Second with
And
discussion.
discussion again.
Thank you. Resolution number 21-121824, resolution eliminating the availability of new memberships in the Golden Full, Gold Mod, and Platinum Full membership rate classes at the Port Jefferson Country Club. Motion?
Motion.
Thank you. Second?
Second. With discussion.
Thank you.
Follow.
Resolution number 22-121824, resolution establishing the attached membership rates at the Port Jefferson Country Club for the April 2025 to March 2026 season with the following changes. Increase of 7.5% in the base membership rate for all available membership rate classes. Increase to $725, a $300 increase, in assessment charge to account for the capital improvement bond and capital lease debt within the operational budget. Increases in the following ancillary fees. $10 increase per player to outing fees. $1 and $2 respective increase to 9 and 18-hole cart fees. $10 increase to 18-hole weekday and weekend guest fees. May I have a motion?
Motion.
Second?
Second with discussion.
And the last one?
No, I can wait.
Okay.
All right, so now we can open these four resolutions up for discussion?
Yeah.
Okay.
Should we
Stan, I
start
think you
with,
started, you wanted to start?
Start with 19.
Well, the whole thing, I mean, look, we have the attached rates.
No, I know, but
Document rate.
I mean, it just feels right to me to 19 and 20 we should discuss together.
I have a number
I
of,
wouldn't blend it with 20 and 21.
Okay.
Questions
Blend it with
and/or
22.
statements.
Okay, Stan.
Number one, I don't know of any established hole-in-one membership. Number two, I don't.
You mean you don't know if anybody is actually a hole-in-one member?
No, I do not see those memberships listed.
I don't know where it came from even.
Yeah, I
It's
don't know
almost
where
like
it
we're
came-
abolishing something that doesn't exist.
Could be.
Right? Do we know where that came from, Stephen? Let me just, can we
I
just
do.
establish something real quick, just for
No.
this whole process? We got a couple of questions from the public about how do these rates get recommended? Is anybody interested in talking about that?
Yeah, I'd love to find out.
So, the Board of Governors was established in 2023 at the end of the year. And it was established through a vote it was nominations and a vote by the membership at large. All members could vote. All members could nominate. All members could self-identify to run. The parameters described in the outline of what constitutes the Board of Governors did not include, maybe in hindsight that was not a good idea, did not include designated number of residents versus a designated number of non-residents. How many people could be residents versus non-residents. So that, we're hearing is kind of an oversight. The CCMAC is the code-established advisory council that does have advisory capacity to the Board of Trustees for issues related to finance. If you read the code, it's chapter 25, for finances, for facilities and facilities management and upkeep and social recommendations. So, and cultural engagement. So those are the defined functions and duties and functions of the CCMAC. So there are 7 members on the CCMAC board. They are made up of, there's 1 non-resident member, and the rest are made up of residents, and 1 resident non-member constitutes the non-member representation. So, and this code was established in, I believe, 1978. So, and it's been adjusted a few times under different administrations to change the constitution of that body. And
Sorry, Don, I don't want to interrupt. I want to make sure I caught it right. You're saying that there's 1 designated slot on the CCMAC for a non-resident to represent non-members of the clubs. Is that what was said?
I didn't say represent non-members.
Or sorry, but to account for their membership. Anyway,
Okay,
there's 1.
can you repeat that question?
Sorry,
Because
I thought you said, and I'm just not as familiar with the country.
okay.
I'm not a member, so.
That's all right.
But you said there's 1 slot or 1 seat on the CCMAC designated for a non-resident. Is that correct?
Correct.
Okay.
Yeah.
A non-resident member.
Yes.
It has to be a member, yeah.
Yes.
So, and 1 non-member resident. So the rest are made up of, 1 is the president of the tennis association, another is the president of the Board of Governors, and the rest are at large appointees, right? The process we went through this year, which took an unusual amount of time to get done, and a longer discussion, but I think we have an opportunity to adjust that process and policy to happen earlier, more efficiently, more effectively. Clearly we do. So the Board of Governors was asked to put together a recommended rate proposal based on, for golf and golf alone. Since there's no tennis rate proposals happening right now. So in the past, and something that was absorbed over time was for some reason, the members of these boards and the council were asked to help advise on the rates that were going to be presented and proposed to the Board of Trustees. So that's how it's been happening. I have not participated in it. I think Trustee Laux has participated in the past, but it seems to inevitably result in disenfranchisement of the volunteers who are putting the rates up for consideration, because, and unless they talk to everybody in the public sphere, including residents, non-residents, and everybody who's a member, unless they get a full-on input from everybody, this is what happens. So I know in my sitting through some of these meetings, I had suggested talk to the families who have juniors at the club, see what they say. And I'm not sure, they definitely didn't hear this, because if they had heard this, I don't think this rate sheet would be exactly where it is right now. So what then happens when the Board of Governors was supposed to recommend the rates to and provide the CMAC for advisory review, and the general manager was part of this entire process and actually facilitated the last rate proposal with help from the treasurer, with help from others who had financial experience and background. That was to go to the CCMAC for evaluation, and the CCMAC is the in-code council to provide the recommendation to, well, that's not exactly in the code, but that's how the code was interpreted for years and years and years. So that recommendation always came from the CCMAC based on, as long as I've been playing golf there, and Stan, you can talk better to that factor, that aspect of it. This year we took a little bit of a different approach because, and Stan, again, please weigh in on this at any point, but we actually went to the treasurer this year and said, and Trustee Ugrinsky helped in this based on her experience with finance and her role as the Commissioner of Finance for the Board of Trustees. Can we look at the budget and see what rates we need to actually charge to balance our budget? It's a weird concept, but that's what we did. So unfortunately, you know, some of these numbers that appear on this recommendation, juniors haven't been assessed for debt, what's it called?
Coverage.
The capital bond and capital lease debt.
So all players, you know, it might not be fair. It might not be perceived as fair, but everybody's using the golf course. Weekday members don't have the same access that full members do. Should the assessments change? The assessment is the assessment, right? It's one person, one assessment. The minimums, which we are contractually obligated to pay to the company that rents the space from us, contractually obligated to pay $400 per person. I don't see anything in the contract that said juniors don't have to pay this. I think it was just waived, and maybe rightly so. I don't know, but I don't understand, you know, how we can overlook that contractual obligation. Can we? Without really delving into the contract, and I don't want to do that, but...
My answer, Mayor, would be you're holding a minor to a contractual provision. So I'm okay, from a legal standpoint, I'd be okay with it.
Okay, so all that said, you know, the residents have spoken, but that's the process that we followed to get to these rates. And if we change these rates, we have to reevaluate a little bit, maybe not that much, but I don't know why I don't know why a minimum per person who has a membership at the golf course, and we are required to pay this to the contracted lessee, concessionaire. I don't know how we got away with this for all these years, but we did. So I'll jump in if need be, but I'm very open to reevaluating the recommendation and, kind of setting it right. And then, next year, going through this process earlier and including people who are stakeholders and have a voice. And I'd love to see half the people who stood up and spoke to us in this meeting tonight get involved, become involved. They've been invited to be involved. And I know we have some policy opportunities to look at for some of the sort of behavioral infractions code, things that are in the handbook, policies that are required to be followed by all members. So unless we enforce those policies will never take hold. So, that's where I'm kind of coming from. My first year here doing this, so I would love to get more involvement in the BOG and the CCMAC. But Stan, please weigh in.
Yeah, in years past, we needed membership, so we created an early bird, and we started our membership rates early enough so that we could offer this early bird after Labor Day. And the committee was made up of a liaison to the country club, the president of the CCMAC, who didn't have a board of governors at that time. We had the treasurer involved, and we had two other people that were selected from the CCMAC. There were 5 people that would sit, and Pat Sullivan was involved. The head pro was involved because the budget is attached to the rates. We worked through the budget backwards to come to the rates. The rates went to the CCMAC from the committee for approval. It went to the trustees after that, and we usually had these rates in place so that we could offer an early bird to create more membership. Now things have changed. We have a BOG, we have a general manager. Our membership seems fairly solid. As a matter of fact, we've probably reached the point where we don't want to go much further. I see a lot of things on here that I'm a big proponent of junior membership, by the way. The minimums, the kids will eat up their parents' minimums, so I don't have a problem with charging children minimums. They're going to eat that minimum up. I don't particularly care for the size of the assessment for a junior. These other categories that are on here.
What are you looking at there?
I'm looking at, this is something that I asked Danielle to send me. It's got a full platinum member, a full golden member, a golden modified golfer. I don't know what they are.
Those are categories that the CCMAC came up with.
A hole in one.
Yeah, that's what's.
I will say that years ago, we voted and the board approved a golden membership for Jim
Daly.
Jim Daly is, I believe, 98 years old, and we gave him a reduced membership at that time.
Yeah, so the other categories were established. It sounded like
Wait.
they were trying to use some of the categories at large that were either, one quick thing. The social membership.
Yeah, I
The
think,
social membership is a misnomer because social memberships at country clubs are for restaurant and just for using the restaurant facilities. So, and typically, sometimes they come with a minimum requirement. Sometimes it's built into their rate. But social membership here is a practice facility membership. So if we want to establish a membership for residents for practice facility, that's a completely different category. And if somebody is utilizing a social membership or practice facilities, all this conversation should have happened before it got to us.
Yeah.
And so that's the frustrating thing for me. But if we need to waiver people because they have a health condition and cannot continue doing something because of that health condition, that's an individual one-on-one conversation with the management at the golf course, right? That's not a trustee decision.
no, it's in the White Book, defined in the White Book as the country club liaison. There were 3 people involved that would make a decision individually. They're not all the same. As to whether rates would be rolled over to the next year. We never gave refunds. I think we had one exception. We just rolled it over and people were very happy with that. They were out for 3 months. They got 3 months credit.
And this year, the exception came when the individual moved away.
Yes.
Yeah, which is fair, right? They didn't play golf one time on it, so. But those are
Mayor, may I? Just, we've been having our sidebar over here, the clerk, myself, and the treasurer, about the possibility of tabling this resolution in whole to have these discussions that should have happened previous to arriving on the desk of the trustees and the mayor this evening. We were advised by the treasurer that if we do that, there's a possibility that the course will run out of money and not be able to cover its bills. So maybe if we could propose, if anything on these sheets we could agree on, to get money coming in and table the matters that may need further discussion, it might be a more fruitful discussion instead of, trying to absorb all of this information after what we've already absorbed this evening.
You say money coming in.
We need some rates approved so we can start accepting, and I'll yield to the treasurer.
But, and question to the treasurer, isn't the income deferred till, 20% of it is not? That's what it is. 2 months or so is not.
That's
because-
correct. There's a deferred revenue piece. However, when we're talking about cash liquidity, there needs to be a certain amount of cash liquidity at any point in time so you can continue to pay all of your bills, including your payroll, including the AP vouchers and everything else until until the new year starts and the new budget comes in.
So, Stephen, do you think if we had the rates in place by Labor Day and we had our 79 members that were on a waiting list pay their dues to get, that would help our financial situation?
Having, the answer to the question is yes.
Yeah. It's put us in a bind.
Okay, so do we want to look at the rates? Why don't we look at what rates are the full-time single, full-time couple, weekday, young adult, 9-hole resident pass, 18-hole resident, and full-time non-resident, full-time couple, weekday, young adult, and hold on the juniors in both, off both pages. Are those the issues that we want to table for now, just those particular rates? Those that are associated with juniors?
That would be my wish.
I mean,
I think those other rates, I think, are in line.
the social membership we can reestablish as a different category potentially.
I
in
would,
between now
yeah.
and the start of the season?
You throw in the fitness center into your social membership.
It's, okay, so it's a practice facility membership.
Right.
Social membership would be related to the dining facility.
Right.
I think, I mean, makes sense. It's what other courses do. So, what
I think all of us have a copy of this, these other clubs. There's quite a bit of discrepancy between what we're asking and what these other clubs that are fairly close to our type of club are charging for juniors. For example, most of the other clubs, Lake Success, Bellport, 350 and 300, Lawrence, 375.
These must have a family member as a member. Lake Success is 350, but must have a family member as a member. This is going to be a very interesting exercise to go through this document, but I'm not sure that this is the right time for now, because pretty much,
No, I think the only thing we have to worry about, we have to get the juniors. Not only the rates, but the playing time. It used to be after 10 o'clock Monday through Friday and after 2 o'clock on weekends. I don't know what it is right now.
Tom Natola, do you know what the playing time for juniors is? There's no restriction?
After 10 o'clock weekdays, after 2 o'clock on weekends, no
Yeah.
guests.
So that's just
And that's adhered to?
Yes, this year. Yes.
No guests. So can you give Tom the mic? Do you know why the no guest thing happened?
It's before my time, but hearsay is that it was abused. And it was put into place in 21, I believe, that no guests were allowed.
Stan, do you know why no guests for juniors was implemented?
No, I do not.
That's another thing. We kind of need to find out. Why was that?
Probably should have the same guest policy that a senior member has.
Well, let's find out why that was discontinued.
Just listening to the conversation and what.
Yeah, I don't think it ever existed.
If I could jump in, it does sound like there is consensus among the membership dues, the club assessments, and the dining credit, except for the assessment and dues for the juniors. Does everyone generally agree with that? In terms of the cash flow problem that we are trying to get through tonight?
Say that again?
It seems like there is consensus between, the only thing that seems that there is not consensus on this proposal that is sitting in front of us is the club assessment and the dining credit for juniors.
For juniors, correct.
Right? Would it be possible to at least, I don't know, like amend just, like focus on just where, if it seems like we're agreeing on everything else in this grid, if we could just come to or have a discussion on those two fees, what's the current dining fee for juniors? 0, correct?
100.
100. And the club assessment for juniors right now? None. So we're increasing the junior by $1,000, which is nearly a 50% increase. That is insanity. And it's like, it's extremely frustrating that we're doing this on December 18th, which I know we all agree on, but it just has to be said. Can we get to any resolution where perhaps the dining credit increases to 200 and they pay half the club assessment? Would that be reasonable? Right now, I'm going on vibes right now, so.
I would make the following recommendation, right? I mean, I think we all agree on everything but the juniors. Can we just please table the juniors and, for now, and approve all of the rest of the rates? The other thing I would recommend is that we can very quickly take 20 and 21 off the table by asking a couple of questions. So my understanding, just shifting briefly to Golden Full, Golden Mod, and Platinum, was that the intent was to allow the current members who are in those classes to continue, and it's a very small handful, right? So instead of eliminating it in its entirety, the plan was to allow them to finish up their memberships, and as a part of trying to simplify the membership classes, that was the intent of taking them off. So these resolutions are really just saying, will we allow that to continue in light of the fact that those categories no longer exist? Will we permit these people to continue having those classes until they age out? So I just wanted to clarify that, because I think these are two that we can just pretty quickly eliminate.
Could we just, I don't even know what a Golden Full, Golden Mod, and Platinum Full membership are. I mean, first of all, how many people are we talking about?
We're talking 4 people, and most of them are super seniors that have been members of the club for years. They use it on a limited basis. So we said to simplify the classifications of membership, we would grandfather them in. We just wouldn't resell that membership any longer.
So we're talking about 4 people. Okay. Thank you.
And in accordance with what the mayor was saying earlier, you could also do resolution number 19 and reestablish a practice membership or whatever's going to be termed, as opposed to the social membership at a later date.
We call that a practice, eliminating social and hole-in-one membership rate classes and establishing the practice facility membership?
We don't even have to do the practice facility
You don't
membership
have to do
right
that
now.
this evening either. We can add that at any
We can add that later, because the
Once we figure out the junior
courses,
numbers, we can add that at the same
next
time.
season, this is for next season, so we'll be good, just with the understanding that there is an interest in getting that done.
Correct.
And then there is also an interest in, making recommendations for the junior assessment and dining credit that will not be as seemingly onerous as it is right now.
So based on that discussion, Mayor, why don't we have let's get the mic back from Tom. Why don't the mayor go through those resolutions, 19, 20, and 21, and where we may need to make necessary amendments, we will. 19, go.
You said the mayor, okay. Okay, so repeat of resolution number 19, 121824, which is a resolution eliminating the social and hole-in-one membership rate classes at the Port Jefferson Country Club for the April 2025 to March 2026 season.
Do we have a motion?
We already motioned everything, right?
Well, just to keep the record correct, we're going to just redo it.
Can we add to that we're going to look at,
On the discussion on the motion, and having it been motioned and second, on a point of order by trustee Giuliano, is that a further discussion will be had to reclassify the social membership.
thank you.
So motion, please.
Motion.
Thank you. Second?
I'll second.
All in favor?
Aye. Resolution number 20, 121824, resolution establishing the continuation of the Golden Full, Golden Mod, and Platinum Full membership rate classes for members already in the Golden Full, Golden Mod, and Platinum Full membership rate classes at the Port Jefferson Country Club. May I have a motion?
Motion.
Do we have a second?
Second.
Can I just ask something about this now? Do we even need to have this as a resolution? Because the next resolution discontinues the availability of new memberships into these classes.
For housekeeping purposes, maybe the treasurer to have that classification still open, should the 4 members live longer. which
Okay.
we hope.
All right, all in favor?
I agree.
Aye.
Aye.
Cleaner. Resolution number 21, 121824, resolution eliminating the availability of new memberships in the Gold in Full, Gold Mod, and Platinum Full membership rate classes at the Port Jefferson Country Club. May I have a motion?
Motion.
Thank you. Second.
Second.
All in favor?
Aye.
Did you want to talk about this again?
The four members that fit that category, are they grandfathered?
That was the
Yes,
previous
that was the first
resolution.
one, yeah. Yeah.
Okay.
Okay. Resolution number 22, 121824, resolution establishing the attached membership rates at the Port Jefferson Country Club for the April 2025, March 2026 season with the following changes. Increase of 7.5% in the base membership rate for all available membership rate classes. Increase to $725, a $300 increase, in assessment charge to account for the capital improvement bond and capital lease debt within the operational budget. Increases in the following ancillary fees: $10 increase per player to outing fees, $1, $2 respective increase to 9 and 18-hole cart fees, $10 increase to 18-hole weekday and weekend guest fees. May I have a motion?
Motion.
Second?
Second.
Just one quick question. This doesn't reflect to whom these charges are assessed, right? So especially bullet 2.
Mayor, I think it's understood that the board's voting on all categories exclusive of the juniors.
Should we note that?
We have to note
Yes.
that.
Duly noted.
Okay. All in favor?
Just how's it going to read? Yeah.
Resolution to say
Resolution.
all categories exclusive of the juniors.
Resolution establishing the attached membership rates exclusive of those related to the juniors.
Yeah, because you can't say all, right? Because the 9 and 18 holes.
Yeah, it doesn't say all. Doesn't even use that word, but still.
Right.
It's helpful.
I'll make the motion on the new resolution.
You already did, and
I
Zena,
did.
Zena seconded, and we just have to vote. All in favor?
Wait, so the only other thing, just because we are still in concept increasing the fee end of the junior membership a lot, there's, regarding the cart fees, in the other document, or in the proposal, it says, members who do not have a valid driver's license can walk on mandatory cart days and are subject to cart fees. So we're essentially requiring cart fees on people that are not permitted to use the carts. Can we at least eliminate that?
Well, that's
To
a
throw them-
policy.
That's just the
That's
junior
policy.
thing. Can we table that to when we?
It's not just
I think
juniors.
it's a good thing to add
It's not just
to our
juniors.
juniors
It's not just
And,
discussion.
and that's policy, so
Okay.
that's not, we're not voting on that right now. Right? We're not voting on that right now.
Okay,
But we should add it to
okay,
the
yeah.
discussion when we.
Because I just saw
before
the
we do.
cart fees in here, but yes, that makes sense. Okay.
Okay, all in favor?
Aye.
Thank you. Resolution number 23, 121824, resolution establishing the policy that all collected Port Jefferson Country Club assessment monies in excess of approved expenses be segregated and transferred to a capital expense line item account to be used for future approved capital expenses. May I have a motion?
Motion.
Second?
Second.
All in favor?
Aye.
Thank you. Resolution number 24, 121824, resolution to enter into executive session at 9:19 PM to discuss a contract negotiation and the specific performance of a particular employee. May I have a motion?
Motion?
Second?
Second, for discussion, there was another item that we were going to discuss in exec. That trustee Hill
Contract?
brought
Yes.
up, right?
Yes.
Okay, it's covered.
There's likely be a vote out of executive session. We usually make that point to the public.
There will be.
There will
added resolutions to the executive session.
Yes.
In all likelihood. So we'll be back, and if Jeff and team can stick around. Thank you. Do we have we did. Did we vote to go into executive? We did.
Recording secretary says no, so let's vote.
Yeah.
Sylvia.
All in favor?
Resolution 24, please.
All in favor?
Aye.
Right.
Aye.
Aye.
All right, thank you. Out of executive session, welcome back. Do we have a motion to come out of executive session?
Motion.
All in favor?
Aye.
Motion carries. All right, turning it over to you, Clerk Perillo.
Thank you, Mayor. We have resolution number 25-12184 from executive session, resolution approving the stipulation of agreement dated December 10th, 2024, between the Village of Port Jefferson and an employee, and authorizing Mayor Shepro to sign the stipulation on behalf of the Village of Port Jefferson. May I have a motion?
Motion.
Thank you. Second?
Second.
Thank you.
All in favor?
Aye.
Thank
Motion
you.
carries.
We have resolution number 26-121824, resolution approving the check register and warrants dated 12/13/2024, as presented by Treasurer Gafka and as approved by Claims Auditor Goodwin. May I have a motion?
Motion.
Do we have a
Second.
second? All in favor?
Aye.
Thank you. We have resolution number 27-121824, resolution approving an agreement with a healthcare provider and authorizing Clerk Perillo to sign the agreement on behalf of the Village of Port Jefferson. May I have a motion?
Motion.
Thank you.
Second.
Thank you.
All in favor?
Aye.
Thank you. We are back to resolution number 1824. Resolution approving the following. Whereas the Village of Port Jefferson is desirous of ensuring that the integrity of the village court proceedings are adequately protected and secure, and an application has been made to and approved by the New York State Unified Court System for the hiring on a per diem as-needed basis of independent contractor court officers from the New York State Unified Court System effective December 3rd, 2024, for 2 officers per court date at a pay rate of $200 per officer per appearance, and said court officers will be used to supplement justice court appearance operations, which continue to be provided by village code enforcement officers. May I have a motion?
Second.
All in favor?
Aye.
Thank you. We now have resolution number 27-121824, resolution approving an agreement with a healthcare provider and authorizing Clerk Perillo to sign the agreement on behalf of the Village of Port Jefferson. May I have a motion?
Second.
All in favor?
Aye. Thank you. We have resolution number 28-121824, resolution to close the December 18th, 2024 meeting of the Board of Trustees at 10:38 p.m. May I have a motion?
Motion.
And a second.
All in favor?
Aye.
Motion carries.
Thank you.
Meeting adjourned.